So good morning, everyone. We are so delighted to have you here to watch what I anticipate will be a fantastic round between two of your colleagues who have succeeded in getting this far and who today will compete for the championship of the Dean Dunmore Moot Court competition. So I would like to have our distinguished panel come into the room at this point, and we will then do all of the introductions. So if you would all rise, please. I may have the permission to tell them all to be seated.
You may proceed.
Okay. So we are so lucky and proud and grateful to have with us today three very distinguished jurists. To my immediate left is Judge Stuart Friedman, who this past January retired after serving on the Court of Common Pleas of Cuyahoga County since 1987. He is a graduate of the University of Pennsylvania. He went to the London School of Economics and has his JD degree from the University of Michigan. And Judge Friedman actually finished his career for Cuyahoga County by presiding over the many, many cases that were brought against university hospitals for the loss of the frozen embryos, which made a lot of news here in Cleveland and nationally. To my right is Justice Melody Stewart, one of the recently elected justices to the Ohio Supreme Court. Justice Stewart is no stranger to this law school, having served as its Director of Student Services several years ago, and she has a distinguished career as an appellate judge on the 8th District Court of Appeals. She also has a degree from the University of Cincinnati Conservatory of Music, and she has been on the faculty of Cleveland Marshall College of Law as well. Sitting directly behind me is Judge Bernice Donald. Judge Donald was appointed to the United States District Court for the Western District of Tennessee in 1995 by President Bill Clinton, and then to the Sixth Circuit in 2010 by President Obama. She was a state court judge beginning in 1982 and has her degrees from the University of Memphis, and she's also worked in both the Public Defender's Office and in Memphis State Legal Services. We are so honored and privileged to have all three of these distinguished jurists here with us today. I want to thank, before we proceed, I want to thank all of you for attending today, and those of you who participated and worked so hard in the competition. I want to thank the Dunmore Board for all of the terrific work they have done, to Professors Grostic and Besser, and a special shout out to Phil Calabrese, who wrote the problem this year and who unfortunately did not make it to your program. So please write him in very fine print, ink, bold, whatever. Without further ado, I'll turn it over to Rachel, who is our bailiff this morning, and we will begin.
Oyez, oyez, oyez. This honorable court is now open and sitting for the dispatch of its business. God save the state and this honorable court.
Thank you. Good morning. The court is now ready to hear the matter of United States of America versus Emmanuel Marr. Are the parties ready to proceed? And if you are, please announce your appearances.
Yes, Your Honor, I'm ready. Joseph Shelton.
Yes, Your Honor, Renee Mata.
Thank you. The court is ready to hear from the appellant.
Good morning, Your Honors. May it please the court, Joseph Schell for the appellant, Emmanuel Marr. I would like to reserve 2 minutes of my time for rebuttal. Emmanuel Marr was denied any opportunity to defend himself at trial when he lost his sole alibi witness during the government's impermissible, non-investigative pre-indictment delay. But, Your Honors, before I get into the details of that claim, I do want to address the threshold procedural issue here regarding why this court should hear Emmanuel Mar's appeal in the first place. And it should do so for two reasons. First, because the underlying rationale underneath the fugitive disentitlement doctrine, namely hearing cases, a strong preference for hearing cases on the merits and ensuring that this court's judgments are enforceable, those goals are furthered by hearing Emmanuel Mar's appeal here. And second, because without any significant interference to the appellate process because of his brief flight, dismissing his appeal would be too severe of a punishment, too disproportionate a punishment in this instance.
Counselor, isn't it kind of disingenuous to want to rely on the law to reverse your case, yet not abide by the law?
No, Your Honor, I think because there are different tests here that apply to different issues. And we're not saying, and also importantly, we're not arguing that Emmanuel Mar shouldn't be punished or should escape any sort of judgment from the law for what he did in his escape. Simply that punishment, dismissing his appeal at this level, is too severe, is too disproportionate, because it didn't affect any part of this process. So it would be possible for him to be punished at the district court level to be prosecuted for escape. His sentence could be adjusted with additional months because of his escape.
But doesn't it reward individuals for a lack of respect for judicial process and for abiding, as Justice Stewart said, abiding by the court's orders? I mean, here, there's no allegation that the defendant did not appreciate his obligation to appear. He made a very conscious decision to do what was his immediate desire rather than honoring his obligation. And what signal do we send if we allow someone to flagrantly disregard the court's orders and then come in and have full process?
Your Honor, I think the message that the court sends is that it's what was followed what the Supreme Court laid out in Deegan as practical considerations for what underlies the use of discretion in this area. Because the fugitive disentitlement doctrine is a purely discretionary law. But it's not absolute discretion either. There are certain guidelines that are required to be met in order for that to be a suitable punishment. And one of them is, again, ensuring that this court's judgments are enforceable. And the way that the doctrine accomplishes that is by bringing defendants back to the court's jurisdiction. And ideally, that would prevent them from fleeing in the first place. But once they are gone, the doctrine is meant to encourage those fugitives to voluntarily surrender, bring them back here for what Deegan says that the dignity of the court is in the court's hands by hearing cases on the merits whenever possible. And so in this case, that's Emmanuel Mar voluntarily surrendered. He's actually furthering the goals of the fugitive disentitlement doctrine by returning to the court's jurisdiction. But if this court were to dismiss his appeal after he did exactly what the doctrine is designed to make him do, the doctrine would turn into all stick and no carrot, Your Honors, and discourage others who have already fled from coming back to the court's jurisdiction.
Briefly, so that you do have time for your pre-indictment delay argument, what example then should there be that your client exhibited in order for this court to say that the fugitive disentitlement doctrine should apply?
Perhaps if he was gone long enough, Your Honor, to interfere with the appellate process, to cause some, if the panel would have to be reconvened or if oral arguments would have to be rescheduled.
Why would that happen? The parties don't have to be present for appellate arguments.
Well, Your Honor, I think in the Supreme Court in a previous case in Ortega-Rodriguez did, and again in Deegan reiterated that those are conditions that do have to be met in order to warrant such a severe punishment as dismissing an appeal in this case, especially when there is a substantive merit claim.
What if you left a note that says, ha, 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 you suckers, I'm never coming back?
Well, if he doesn't come back to the point that he would significantly interfere with the process, then that would be a much tougher question, Your Honor. But there have been cases even where defendants have fled multiple times while on bail, where they've been gone for up to 5-6 years, and they've come back and the court has still agreed because of a meritorious claim, because of a substantive claim, the appellate court has still decided to hear that claim on the merits.
So the overarching aspects of the law and justice should prevail over a defendant's temporary flight.
Isn't there a more fundamental issue here? according to the materials we were given, he pled guilty. Am I correct?
That's correct, Your Honor.
Not nolo contendere, not no contest.
That's correct.
And he did not preserve the right to appeal, did he?
He did preserve the right to appeal on the specific pre-indictment delay issue, Your Honor. That is an explicit part of his plea arrangement, is that he does have the right to appeal this issue.
That was not provided to us.
I believe the plea agreement is part of the record. I don't have the exact record cites, but it is around pages 65, 70 of the record. There is his plea agreement should be in there, and this carve-out, the specific carve-out for appeal on this issue is part of that plea arrangement.
So let's assume that you're correct there. So what's the argument, and what's wrong with? I mean, why should he prevail on that claim since the government really, according to the facts, didn't do anything overtly or actively to frustrate or to delay in the indictment? Somebody was killed. The case was transferred to another agent. Why should he prevail on a dismissal of the indictment under those circumstances?
Two preliminary points there, Your Honor. I think there were some intentional decisions made on the part of the government, maybe not necessarily to frustrate the defense, but certainly in how the investigation was handled. How they assigned financial resources, how they divvied up personnel resources, who they chose to investigate, and when. Those were all intentional decisions that the government did make that had an effect on the investigation.
Did the government, though, actually deny financial resources? I know that there was a budget item, but was there actually a denial? I thought before that was acted on, the catastrophic event that led to the death of Agent Perez occurred.
There were some budgetary issues that Agent Ernie testified to, sort of generally speaking, at the FBI. So they didn't have enough financial resources, as many as he would have liked to continue the investigation. But those are still, and courts have recognized, even in circuits that impose a bad faith standard, which I'll get to in a moment, even circuits that impose that standard have recognized that those are intentional choices and that those might be enough to result in a due process violation in cases of extreme prejudice to the defendant.
So doesn't Lovasco, though, really hurt your position here? Because there was a substantial delay, and the court said that really the government should not rush to I mean, there are legitimate reasons, and the government shouldn't just rush to an indictment. Maybe there are considerations that the government should weigh that actually protect the public, protect potential defendants. So doesn't that argue against you?
Your Honor, that really gets to the heart of our position here, and that's that Lovasco is not controlling in this issue. At the very beginning of the Lovasco opinion, the Supreme Court said there the very narrow question that it was deciding was whether, when there was actual prejudice because of an investigative delay by the government, whether that could result in a due process violation. But here, the district court found non-investigative reasons for the government's delay. That was one of the findings it made during the pre-indictment delay hearing, and as a factual finding, that would be entitled to clear error deference for the standard of review. So because there are non-investigative reasons for the government's delay, Lovasco doesn't necessarily control on this issue, because that was only about investigative delay.
Finish your answer.
And whether that would result in a due process violation.
So do we have to look at whether there was bad faith on behalf of the government?
No, Your Honor, and that gets to the broader, I think, takeaway that we can use from Lovasco is that, and when the court there reiterated what it said in Marion, is that any of these pre-indictment delay analyses are guided by the fundamental principles of the community's sense of fair play and decency. And several...
let me stop you there. So there's a statute of limitations on crimes, correct?
Yes.
And the indictment was brought before the statute of limitation.
Barely, Your Honor, yes.
Barely, but still got there, right? So how do we do this balancing, if you will, between what constitutes pre-indictment delay that is so violative of due process or so prejudices the defendant, when the state still had time, according to the statute of limitations, to bring the charges?
And that's where the prejudice comes in. I think that's where the prejudice prong comes in, because when, I think...
So what's the prejudice for your client? The alleged alibi witness?
The death of the alleged alibi witness.
Okay, let me stop you right there. So is there anything in the record to indicate what this alibi witness would have said other than your client's own self-serving statements?
Not the exact words that he would say, Your Honor, but the exact words that this witness would offer are not required to prove actual prejudice. What's necessary is just that the defendant can describe the subject matter of that witness's testimony in enough detail to determine.
So what evidence is there that this witness would have said, yes, I was with Mr. Marr on this day?
That he would say that exact.
He doesn't have to say exact, just, yeah, we were together, however he says it.
Well, I think all we know from the record is that he would have offered testimony regarding where Emmanuel Marr was. Whether he would have said, yes, he was with me, or no, he wasn't, we don't know that because that's not in the record.
Well, then if he says I wasn't with him, there's no prejudice.
If he would say that, Your Honor, then that would be right. However, to prove actual prejudice for a witness's testimony that's been irretrievably lost through no fault of his own, Emmanuel Marr only needs to show the subject matter of that testimony and that it's not cumulative and that it can't be replicated by anybody else. And in this case, there's nothing in the record that demonstrates anybody else could offer testimony about where Emmanuel Marr was on that day. Even Emmanuel Marr's co-defendant in this case was asked at the pre-indictment delay hearing about where she was on that day and couldn't remember. Couldn't remember where she was, couldn't remember whether a meeting took place, couldn't remember if anybody else was even at this meeting if it did take place. So the only other evidence that anybody attended this meeting is solely from the government's indictment. There's nothing in the record to indicate it ever actually happened. And if the co-defendant in this case, was just as much reason as Emmanuel Marr to remember what happened that day and who was there and where she was, if she can't remember, it's highly unlikely that anybody else would be able to remember that as well. And that's enough to show actual prejudice when there's been a lost witness. Again, because Emmanuel Marr wasn't even indicted until 4 months after this witness died.
Well, you know, the test is more than just prejudice, isn't it? And what test are you arguing that the court look at? What is the degree of prejudice that needs to be demonstrated for you to prevail? And are you arguing some, I don't mean a bright line, but are you arguing some test that the court ought to employ in making that determination?
There is a test, Your Honor, and it's not a bright line one. It is an objective sort of fairness test guided by these fundamental conceptions of fair play and decency laid out in Lovasco. So the test is the defendant first has to show actual and substantial prejudice, as the district court found in this case. And then the burden shifts to the government to come forward with its reasons for its delay. And then the court weighs those against each other and determines, based on the degree of prejudice and based on the reasons that are given, whether it would be fair to make the defendant stand trial in that case. And in this case, and I see my time has expired.
Finish your answer.
In this case, when Emmanuel Marr has been deprived of his entire defense, his only alibi witness, and the government has offered nothing but administrative and bureaucratic, but no investigative reasons for delay, that prejudice is not outweighed by those, and his indictment should be dismissed. Thank you.
Thank you. For the appellee. You may proceed.
Good morning, and may it please the court. My name is Renee Monzon, and I represent the United States appellee in this matter. We are here today despite Emmanuel Marr's continued efforts to evade justice. Now he seeks relief from the same judicial process he refused to do today. Today, we ask this court to dismiss Marr's appeal under the Fugitive Entitlement Doctrine because he fled the jurisdiction with the specific intent of avoiding criminal prosecution, and dismissal properly serves the policy goal.
Well,
Didn't he say?
prosecuted, wasn't he?
Yes.
Yeah, I'm sorry, wasn't he already prosecuted?
Yes, Your Honor, but in United States versus Ortega-Rodriguez, the court said that prosecution extends beyond the normal term that we use it for to after prosecution ends, to when the appeal is filed, and the entire judicial process.
Is that a good decision? Is that a logical analysis?
I believe so, Your Honor, because fugitive entitlement doctrine has applied to many times when cases are on appeal and being heard by appellate courts, because they are the ones with the authority to dismiss cases when a fugitive doesn't appear. And so this court.
Well, in this case, I mean, even though he did fail to appear timely, he advised the jurisdiction that he planned to come back at a certain time in the future, didn't he?
He said he would come back when Mallory Parrott faced music. He did happen to return when she was sentenced, but this statement wasn't specific as to when he would return.
Okay.
And here, he was gone for approximately 2 weeks.
So why isn't some subsequent criminal penalty sufficient? Why does he have to forfeit his appeal?
Your Honor, that may be sufficient, but this court has the discretion to dismiss his appeal, and it would be the easiest to deal with at this level.
But why? I mean, it was filed timely. He is represented by counsel. Defendants don't have to appear for oral arguments or for anything. I don't think Mr. Maher was tasked with the responsibility of writing his own brief. What difference does it make whether he is here to prosecute his appeal?
Your Honor, the enforceability may not be an issue, but we do need to look to the other rationales for dismissal under this doctrine, whether that be reinforcing respect for the court or discouraging future escape. He did leave and failed to report when he was
He wanted to spend time with his girl.
Yes, but he also did leave his wife and 3 children at East
Oh,
Reserve.
well, that's problematic. Okay. Point taken. Go ahead.
When he left, he failed to report to custody on his surrender date, and he filed a public declaration that insulted the judicial process and conditioned his return on Mallory Parrott's music. And this declaration showcases the intent that's required under 28 U.S.C. 1466. In the United States versus Texas, individuals involved in a conspiracy tried to condition their return on being released on bail when they returned. And the Second Circuit used this attempt to condition their return as a fulfillment of the specific intent requirement by fugitive disentitlement statute.
Okay, well, you know, that may be the case, but he did eventually come back, and it seems to me that while his actions may have been inopportune, they may have been somewhat insulting, should we, in fact, allow that to trump fundamental fairness, which is to decide this issue and require him to forfeit his appeal? I mean, are we talking about an equivalency of conditions here?
Your Honor, the court does need to balance the different rationales for dismissal. And here it would be an appropriate opportunity to dismiss, as he is such a public figure, who would properly deter future escape and discourage people from filing these declarations, flouting the authority of the court and leaving.
Well, we'll go back and ask what we asked Mr. Schell. Wouldn't some kind of additional penalty be an appropriate sanction to accomplish the objectives that you've just announced? I mean, somebody getting additional time in prison, isn't that an appropriate sanction to send the message that you're talking about?
Your Honor, that may be an appropriate sanction to use in this case, but it would require additional action on the part of this court and the district court. The lowest use of judicial resources would be to dismiss the appeal here because he disrespected this court and because he failed to report when he was supposed to.
That sounds like a pretty harsh sanction. He was not AWOL until the day he was supposed to report. Am I correct?
We don't know the exact day he left.
Well, it doesn't matter when he left. He could have left, and if he had come back on August 22nd and reported, there would be no harm, no foul. So he was not AWOL until August 22nd when he was supposed to report to begin his sentence. And he reported 2 weeks later. The Court of Appeals, the district court, was not harmed in any way, was it?
Other than its disrespect, no.
Does the government feel more strongly about this argument, the disrespect for the law, or that your case is strong, that you can survive a pre-indictment delay finding?
Your Honor, we believe that the government has a strong case for both sides, and even if you choose not to apply the fugitive disentitlement doctrine to Mark's case, the government still succeeds on the merits. Turning to pre-indictment delay, the district court appropriately denied Mark's motion to dismiss for pre-indictment delay because The government's investigation did not amount to the intentional bad faith delay necessary for a due process violation.
Do we have to use the bad faith analysis?
Your Honor, the bad faith analysis is derived from the most appropriate reading of United States versus Velasco and used by a majority of the circuit court.
But what about just the simple balancing test? I mean, there may not have been any ill will or bad faith on behalf of the government, but at some point, if the delay causes a total destruction, if you will, of the defendant's case, how is due process served by then allowing the prosecution to continue when his entire defense is depleted?
Your Honor, even if you did apply the balancing test in this case, the government still succeeds on the merits. Here, even if Marr was somewhat prejudiced by the delay, this doesn't amount to the actual and substantial prejudice necessary for a due process violation.
His only alibi witness is dead?
Your Honor, there's nothing on the record that shows that he was the only alibi witness, and to prove substantial prejudice.
Is there anything to show that there are other alibi witnesses?
There's nothing to show that there were other alibi witnesses. On page 40 of the record, Agent Nerney does say that there were other people, or they had other evidence that Marr was at that meeting. There were 7 or 8 other individuals at the city council meeting who could testify as to whether Marr was there or not.
In the other part of your argument, you urged us to sanction Marr for his failure to show proper deference and respect to the court, leaving the jurisdiction here. What should be the sanction against the government, who has all of the resources and the duty to investigate the case and timely and properly indict? And I'm aware that the indictment did come within the statute, but here the individual is really at the mercy of the government to decide when they're going to pull the trigger on the indictment. Why shouldn't there be a sanction against the government when the government had all of this information and simply basically let the case lie fallow for all this period of time? And during that period, the defendant, Mr. Marr, suffered some prejudice.
Your Honor, I think that mostly comes down to intentionality. Here, the government didn't have any intention for the delay. It occurred because the chief agent actually died in line of duty.
But the case was transferred to Agent Nerney, who admitted that the box sort of sat there and he didn't go through it until much later.
Your Honor, Agent Nerney wasn't aware that the file had been transferred to him for approximately 11 months.
Okay, but Agent Nerney is a part of the government team, and so to say that he individually wasn't aware, this is government activity or non-activity.
Yes, Your Honor. And in both the United States versus Marion and United States versus Leader, they found that a delay that was due to investigations that weren't continuing wasn't enough to show that the government intended to delay the investigation, which is necessary to constitute a due process violation in this case. And here, the government had budgetary constraints, they had a high caseload and low personnel, and these factors that are mostly out of their control, we don't want to punish the government even when they do diligently investigate a case and manage to bring it within the statute of limitations. And here in United States versus Velasco, Justice Marshall said that only deliberate attempts to disadvantage a defendant to intentionally delay their case rise to the level of a violation of the standards of fair play and decency that's central to our judicial system.
What about the cases subsequent to Lovasco? Have they altered that at all?
Your Honor, in the cases that apply the due process, they mostly abide by these standards, that there needs to be some sort of intentional action on the part of the government to deprive the defendant of their due process rights. And so we can see that in cases like United States versus Cornell, where they looked at, it's not a question of whether the government exercised enough diligence, it's a question of whether they acted intentionally in depriving a defendant of their rights.
Would you feel the same if your assertion is that there is other evidence or other ways that Mr. Marr could prove his alibi? If there were not, would you think he was prejudiced by this delay?
Your Honor, it could be possible. If he could prove that there was no other way he could obtain this evidence, he could be prejudiced by it. But we don't have that information.
He could be, but would you concede that he would be?
I believe that under those circumstances, he could be. But that's not what we have at issue here. And even in United States versus Crutch, it says that the pre-indictment delay doesn't amount to a due process violation when it's merely speculative or they don't know what the key witness would have said if he was able to testify.
That's true. That's true. But before you just made that concession, you said, I believe, that there has to be a showing of bad faith. And so assuming that there was no bad faith on behalf of the investigators in this case, if there was no other way to prove his alibi but by this witness who is deceased, you said, I would agree that would constitute substantial prejudice. And so then the case should then be dismissed, even if there was no bad faith on behalf of the government?
No, Your Honor. Even if there is substantial prejudice to the defendant, there still does need to be some showing of bad faith or action on the government.
Okay.
And here, we can see that they validly investigated the case. Yes, there was 5 years between the 2013 meeting and his indictment in 2018, but the public health crisis didn't arise until February of 2014. And then the FBI had to trace lead poisoning to faulty pipes to water change legislation, to a specific meeting where Mark pressured city council members to adopt this legislation. The FBI opened their investigation in April of 2015 and began diligently investigating the case, collecting over 200 interviews worth of information and over 1 million documents. And the only delay that occurred was because the chief agent on the case was killed in the line of duty. And this imminent behavior that we want to punish the government for in dismissing an indictment.
Why not? Why shouldn't we hold the government to a high standard in deciding whether to prosecute someone?
Your Honor, we do want to hold the government to a high standard, but we also don't want to rush them into filing indictments. We want to give them adequate time to find the probable cause required for an indictment. And
But
in fact,
you've already said that the reason for the delay was the 11 months then when the file was sitting there and the prosecutor simply was unaware of it. You've raised the possibility of lack of funds or high number of cases. Aren't these issues that the government should bear responsibility for?
Your Honor, the government should be diligently investigating these cases, and here they did it as best they could. But we don't want to dismiss an indictment when they are doing everything to the best of their ability. And here, even though there was no knowledge on the part of the agents who were involved with the case, and knowledge is required.
There was no knowledge of what?
So the cases that the files were in their possession.
Now, I want to go back for a second because you just indicated that there were all of these documents being collected and all of this activity and investigations going on. All of this did not, even though Perez was the lead agent, all of this was not reposed in this one agent. There was a team. And so why shouldn't the knowledge of the team be attributed to the other folk on that team when this was a high-profile case? So I'm not sure how you make the argument that somebody didn't know, because this was a substantial and high-profile investigation.
Your Honor, there's nothing in the record, I came up
Just briefly.
There's nothing in the record that shows that there was a team of agents. And in fact, Agent Nerney says that when Agent Perez died, that he didn't know of anybody else who was working on the case at that time. And because the government did not engage in any sort of backwards action, and because Manuel Mondo was prejudiced by this delay, we asked first that the court dismiss this case and review the document or a witness report.
Okay, thank you. I'll just have to say, though, given the description you just made, I think it would be the government, this should be looked at in terms of whether or not the government approached this with an understaffed investigation. So, thanks. We thank the parties for. I'm sorry, you left time for rebuttal. How many minutes?
2.
Thank you. Sorry. Thank you, Justice.
Anytime.
Your Honor, 2 quick points on rebuttal. One, I want to address this, the argument that opposing counsel made that this is not about punishing the government. That's not what due process is about. It's about protecting the rights of the defendant here. It's not about punishing the government for what they did during the investigation. It's about giving defendants an opportunity to defend themselves with some sort of evidence, ideally. And as opposing counsel said, that the only reason we don't have any, or that if we would not have any other evidence, aside from Koch's testimony, that would have prejudiced, or that led to prejudice for Emmanuel Mar, then that would be a due process violation, or that would at least count as actual prejudice. The reason we don't have any other evidence is because the government didn't provide it. Agent Nerney had every opportunity at this pre-indictment delay hearing to not just say we have this other evidence that Mar did something, but to bring it to the hearing and to show the court that any part of these millions of documents or other witness interviews had anything to show about Emmanuel Mar's culpability in this matter, and it failed to do so. And so because Emmanuel Mar has suffered high prejudice, complete devastation of his ability to defend himself in this case, and because the government, again, has offered no investigative reason for its delay, simply administrative and bureaucratic ones, under that balancing test that we see as rooted in ideals of fundamental justice and fairness, this indictment should have been dismissed at the lower court level, and we ask that this court reverse that court's decision. Thank you, Your Honors.
Okay, we thank the parties for your argument. The matter is submitted, and we will give you our opinion in due course. Today,
So if everybody will hang out here for a few minutes, the judges will deliberate, and then they will return and give feedback and announce the more final round winners. You know what, I have to say, I felt so good about it. It went on a little bit more. Yeah. I'll talk to you later.
All right.
You may be seated. Okay, I'm not going to make any announcement right now, except to say that the court has deliberated on the case, and at the appropriate time, we will have some comments. I understood that we're going to make some comments now, and the way I would ask is that our newest justice give some comments. Justice Stewart.
Okay, great. So I get to start off and say everything, and then they won't have anything to say, because I'll...
That's the plan.
I have obviously been doing this for a while in both my profession on the Supreme Court and on the appellate bench, but also as a judge in quite a few moot court competitions. And as I just told my two colleagues, I have never, and I mean this, had such a hard time in determining, in choosing someone as a winner. You both were absolutely, I got to tell you, I thought the tattoo would be distracting at first. I'm just saying. Then you got up there and you can't really see it until you did one of these. And so I'm going, how far up does it go? What is it? So just saying. But you all were very, all the check marks, preparedness, knowledge of the law, belief in your positions, ability to respond to us, knowledge of the case law, all the things you need. I wish your preparation, I'm not saying you particularly, but preparation at this level would extend into the practice of law when you get to, levels, because without question, these arguments are always so much better than the ones that we generally get in real life. Even when you're arguing through the clinics, they do a great job. So your eye contact with all the members of the bench was great. Your voices didn't go up or down. You didn't get emotional. You didn't act like this was a trial. And you didn't bang. Sometimes in appellate advocacy, people forget it's appellate advocacy. It's an intellectual discussion, and they bang on the podium and they flail their arms. And I'm not going to flail my arms because this is one of your school's robes, and it's got this thing. They flail their arms. Because my robe isn't here. So, so it was refreshing, and I almost wish you each had an additional 15 minutes, because there were so many more questions I wanted to ask or to tackle you about, but it was an outstanding.
I'm sure they're both very grateful that they don't have.
Oh, really? You could have said more. After you got into it, didn't you want to keep going? Yeah. Good answer. So it was a spectacular argument, and I enjoyed it. Thank you.
Justice Friedman, do you have any demonstration you want to make? You want to flail?
First of all, to be called Justice Friedman is quite an honor that I've never earned. Judge works just as well. I was thinking back to my final appellate argument in the 8th District Court of Appeals here in Cleveland, in which the appellant's attorney waived oral argument, and I was under strict instructions, we don't waive. That's a quick way of getting fired from your job. So I was standing in the Court of Appeals, and Judge Pryatel was presiding, and normally it was 15 minutes, and at the close of about half an hour, Judge Pryatel said, Mr. Friedman, Normally, we have reserved 15 minutes per side. You've been going for half an hour. And I just looked at him and said, well, it's amazing how time flies when you're having fun. And I was. And it was clear that both attorneys here, and I use the term attorneys rather than students, both of you were, if not having fun, at least getting into the whole idea of appellate argument. And that's good. The fact that you were prepared is wonderful. And I'll go along with Justice Stewart, and despite the fact that your name is spelled wrong.
No, E is right, U is wrong.
When she said that she's never had so much difficulty finding one side over another. And this is particularly difficult because one of you is the winner, the other one has to be the loser. We have no choice. It's like in...
I want a dissent.
Mm-hmm. Yeah, me too.
Dissents are very nice, but they don't work. It's like in a baseball game.
It becomes
Yes,
the majority.
absolutely.
It's like a baseball game, football game, basketball game, all of which we have lots of experience with in Cleveland, both pro and con. And, one side scores more than the other, and one side walks with their tail between their legs, unfortunately. So that's what I have to offer. It was particularly difficult to come up with a decision one way or another. So, Your Honor.
Thank you. Well, I will tell you, this has been an incredible argument of significant issues that obviously the courts are facing, and I would join my two colleagues in saying that you both did an incredible job. Let me just tell you, you were both very confident. If you had any nerves going, it wasn't apparent once you took the podium. You took the podium confident but not arrogant. You were respectful and appropriately deferential. You took in the entire bench when you made your argument, and that's the way it should be. No matter who asked the question, you always included the entire bench in your answer. One of the things that offends me when I'm on the circuit is if an advocate believes that they have me on a particular issue and they just sort of lock in on me, I'm offended by that. And, a judge they try not to, but I think a judge may actually head nod or something. People try not to, but human nature is what it is. You're never going to read that judge. Sometimes I will ask a question that does not give any indication that that's the position that I'm leaning toward. And I do that sometimes intentionally. But you always included the entire bench when you were responding to a question. You never talked over the judges. You answer the questions, and judges really appreciate you answering the question. It may not be the question that you want, and sometimes it may not make a lot of sense, but at least you humored us and you responded to the questions. If we threw out a hypothetical without giving you a flag, you didn't come back and say, well, that's not, those are not the facts of this case. You went ahead and responded and got back into your argument, and that's the way oral arguments should occur. I'll digress and tell you that I was doing a moot court at Virginia, and a judge from the Fourth Circuit mentioned that the advocates were there making an argument in a real case, and the case was not a strong one for the appellant, but she thought there was one issue on which the appellant might prevail. And in the course of the argument, she asked a question of the appellant about a particular issue. Let's say, what about, XYZ? And she said when she asked that question, the appellant paused. The oralist paused, then turned and walked back to his table and took a long sip of water, returned to the podium, and went on to something else. And she said, excuse me, counsel, what about XYZ? And he said to her, I don't want to talk about that. and he didn't, and he lost soundly.
No.
But so don't ever do that. And I'll also tell you, you were not in trial lawyer mode. You were in the oral advocates mode. We have an issue sometimes with people who forget that there's no jury. I think Justice Stewart said earlier that this is a conversation about these important issues, and you treated it that way. So anyway, you were excellent, you were wonderful, and the reason I dissented with Justice Friedman is because I believe that there are no losers in this competition.
I concur.
I believe that one of you will get a plaque, but I think you're so prepared that you don't lose here, because the knowledge that you gain and what you've been able to demonstrate makes you all a winners. It's just that one of you will get a plaque. But this has been an amazing competition. So that's the reason I dissented, Justice Friedman. Anyway, okay, so.
Can I, if you will?
Sure, please.
Can I see a show of hands of who thinks the fugitive disentitlement should apply in this case? Are you all familiar enough, or is the audience familiar enough with it?
They've argued this case.
Oh, is this like the whole board? How many of you think the fugitive disentitlement should apply? So, okay. So that means I'm assuming the rest of you do not, or is there anybody on the, who's on the fence? Okay. How many people think that the pre-indictment delay should have the case be dismissed?
Kind of decides,
right.
let's decide which side they argued.
Okay, just curious.
Okay.
So I don't know what
Anyway.
happens. Professor?
Okay.
Well,
The next
thank you, justices, for coming today. Before we get to the actual thing that everyone wants to know, I have a great thing to say. We are so thankful to have you guys come and participate with us. So this is a little gift of our
Thank you.
appreciation.
Thank you so much.
Thank you.
No, thank
Okay.
you guys. And for those of you who don't know me, I'm Rebecca Cameron. I'm the president of the Dunmore Court Board, and we have a few awards that we give out every year for oralists as well as for the brief, and those we'll give out before we announce the champion of this year's round. So first and foremost, for the best brief this year, it goes to Chelsea Fletcher. Next, we give an award out for the best oralist who did not advance into the Sweet 16. So for this year's competition, there were 27 students.
Wow.
And that goes to Jacob Halpern Walsh. Finally, we give an award called the Dean Dunmore Award for the person who gives the best oral scores but doesn't make it to the final out of those who advanced and made it into the semifinal. And that goes to Vito Gianello.
Thank you.
And I'll turn it over to you.
I see that Mr. Calabrese has got here too, so I heard you created the problem. So you want to acknowledge, you were acknowledged earlier, but hadn't quite made it yet, so
Right.
great problem.
You know, actually, I had this issue on the trial court, this pre-indictment delay issue, and
I did too on the 8th
yeah,
District with
right.
rape cases.
yes. Anyway, but this was a very, very close competition, and we agonized over it. And you might say, well, you all weren't back there long enough to agonize, but we agonized quickly. Okay, so but because you were both so good, we actually have a split decision, but by a 2-to-1 vote, the competition is won by the appellant, Mr. Shell.
Another round of applause for our fabulous panel.
and the rest of the Dean Dunmore Court Board. And to our fabulous oralists.